The Justice Minister concedes the proposed anti-terrorism law is pretty draconian, but he also thinks it's necessary to keep New Zealanders safe. I asked Andrew Little exactly what restrictions could be placed on the individuals he's targeting.
It would limit where people could go. It would could require them to have to, for example, go to the police station once or twice or more times a week. It would restrict them from having access to the internet. It could provide a level of curfew, but not a 24-hour curfew. So restrictions from quite severe to quite relaxed.
Who are you targeting this at?
Anybody who's been engaged in terrorist or violent extremist activities overseas and who still poses a risk.
So this is pretty invasive stuff and wide-sweeping powers. Is there a conflict here with people's human and civil rights?
It is a constraint on people's absolute freedoms, no question about it, but we're dealing with people, and this would only ever apply to a small number of people, who continue to pose a risk. So people, for example, who travel overseas in order to engage in terrorist activity, violent extremist activity, and whether or not they've been convicted overseas, but who still pose a risk. When they come back to New Zealand, it is right that we take steps to prevent them being a risk to New Zealanders, and while we have time to assess just what level of risk they pose.
That's the thing, though. They may not have been convicted of any offence whatsoever, yet they could have these enormous restrictions placed on them. I mean, how are you going to assess their threat level? Where is the proof going to come from?
So that's on the basis of the best information available about where they've been, what they've done, who they've associated with. And the way this operates is the police, having assessed somebody as posing a risk, would have to go to court to demonstrate to a judge that this person, on the basis of whatever evidence is available, does pose a risk and justifies these restrictions. It would be up to a judge to decide. If and when that person then makes it back to New Zealand, crosses our border, they're obviously then advised of the restrictions on them. They're also advised that they have a right to legal aid to challenge or to review the orders on them, and they can go through that process and they'll be supported to do that.
The level of evidence required here is based on the balance of probabilities, not beyond reasonable doubt, so a lesser test than at a criminal trial. And you were talking about making these orders in the absence of the individual at the hearing.
That's right, and the safeguard against that is that when they then do cross the border and are subject to those restrictions, where an order is issued by the court, they then have the right to and will be supported to seek an immediate review of those restrictions. The reason why the level of evidence required is at the balance of probabilities level is because they're not being convicted of anything, but they are being restricted because on the best evidence available, they pose a risk to the New Zealand community.
Some people will think this sounds draconian. Is it?
Yeah, it is pretty draconian because in the very, very small number of instances where New Zealanders or people holding a New Zealand passport have gone overseas and carried out violent extremist acts, whether in pursuit of some political cause, religious cause, ideological cause, and then seek to come back, then it is right that the government, the authorities, seek to make sure that the rest of New Zealand is safe with their presence back in New Zealand. And a lot of that will be about having the time, the means, to assess what level of risk they pose.
And it's going to be done behind closed doors, isn't it? Because it's going to be prohibited to report on these cases unless expressly given permission by the judge. So you're going to make what you've described as perhaps draconian measures behind closed doors in the absence of the person you're making the order against, and with a lesser level of proof.
Yeah, because we're not talking about conviction here. We're talking about somebody who is assessed as posing a real risk to New Zealanders.
But what you are talking about is extreme restrictions on their movements, their access to the internet, to phones, potentially electronic monitoring, curfews, no-go zones unless with a police escort, even perhaps banning them from having a bank account. So this is incredibly serious stuff, isn't it?
And that's why it will only apply in the most incredibly serious of cases. There are people who have gone, New Zealanders, people with a New Zealand passport who have travelled to conflict zones. And we know that there's an obvious example, and people have talked about it, Mark Taylor, with the express intent of participating in violent extremist activities on, with a religious cause, and have engaged in that sort of activity. They haven't renounced their views. In fact, within the last 2 or 3 years, he in particular called on New Zealanders on Anzac Day to kill veterans and retired servicemen and women. So these are the sorts of people we were dealing with. If they want to come back to New Zealand, which would be their right to do so, I think it is only right that they are placed under restrictions so we can assess the level of risk they pose to New Zealand.
But are you making a law for one man, in essence?
No, I
Mark
think...
Taylor.
No, there are. We know that there are other New Zealanders or holders of New Zealand passports.
Minister? How many?
It's a small number. It's 3 or 4 adults who would fit into that category. But also we know with the rise of other, and it's not just religious extremism, it's all forms of violent extremism that is on the rise around the world. There are New Zealanders who are attracted to that, and you cannot rule out that at some point in the future other New Zealanders will find it attractive to go to other parts of the world, indulge their violent extremism and want to return. And if they do that and are known to the authorities, we want to make sure that once they return, they don't pose an undue risk to the rest of New Zealand.
This is a step too far, though, for the Greens, isn't it? They have said that they don't support it. What discussions have you had?
Look, they were briefed on it. They indicated, they took some time to consider it, but they told me that they don't support it.
National, on the other hand, says it's not tough enough. I mean, are you going to have the support to get this over the line?
Well, National have said they'll support it to the first reading. I mean, I would hope that we're not get into some mindless sort of political who's got the hairier chest sort of argument, which is what the National Party seem to want to get the argument to descend into. I'm not into that. I think the bill, as it stands, strikes the right balance between understanding that there are people, and very, very small number, but people with extreme views who engage in violent extremist acts who would pose a risk when they return to New Zealand, and this is a way of mitigating that risk, also having time to assess the reality of the risk they pose, allowing them much freedom of movement, but some limitations on that so that the rest of New Zealand is not at risk.
Is it dog whistle politics?
No, we have a very real situation because of what's happening in Syria now and the rapidly changing environment there, with at least one New Zealander who has engaged.
Which brings us again back to Mark Taylor, Minister, because what it looks like to some people is that you are tailoring this law to one individual.
Well, he is an obvious risk, and it would be reckless and irresponsible, knowing that he's expressed a wish to come back to New Zealand, knowing what he has done, knowing what he's participated in, knowing what he went to that conflict zone to do, for him to come back here and we do nothing about it when he clearly still poses a risk. Is
there some suggestion that he has been released from jail and his arrival home is imminent?
I've had no advice in that regard. The last I knew, the last advice I had is that he was still detained in a facility in Syria.
And that's the Justice Minister, Andrew Little, there.